Assalamualaikum warahmatullahi wabarakatuh, and also a very good evening to everyone that is watching my video. My name is Saisha bin Said Musafa, and today I'm going to talk about the law about terminating construction contract. And by doing this, I will show you guys the two real cases to make sure that related by the PWD PWD Form 203A with Palm Contract 2018 and CIDB 2000. So the cases below specifically address the consequences and failing to follow strict contractual procedure and the procedure for lawful termination. With that further ado, let's begin. So the first case is Jabatan Kerja Raya Malaysia aplikasi Sunisa Sedia Berhad. The fact of the case is the contractor Sunisa Sedia Berhad was delayed and granted an extension of time (EOT) under the contract, and the contractor subsequently submitted a claim for a lost expenses due to the delay. However, the contractor failed to comply with a 30-day notice period required by the clause 44.1 in PWD D203A form the employee JKR, which refused to pay that the failure to serve a notice on time that barred the claim. So, in that case, the High Court had initially allowed the part of the claim to distinguish between the losses that were beyond those within reasonable consumption. And the issue of the case is basically on the clause 44.1, the constitutional perspective is that it is the 30-day notice requirement and mandatory condition precedent of any loss expressive claim, and also the reasonable of contemplation. Is there a legal distinction between the loss within reasonable contemplations? And the Court of Appeal allowed the employers to appeal finding in favor of the government. Why? It's because number one is no distinction in lost time. The Court of Appeal overturned the High Court distinguished it held that the words beyond the reasonable contemplated in clause 44.1 do not create a separate category of a loss that exempts for the notice requirement. The clause is exhaustive regarding the low claim loss due to delay. And this case is definitive authority on the clause 44 of PWD 203A, and it confirms that the time limits for submitting claims are condition precedent. If a contractor fails to submit notice within the stipulated time, and they lose their rights to claim that loss and expenses entirely regardless of the merits of the delay. Now, the second case that we're going to talk is Kementerian Pendidikan Malaysia against the contractor. So, the facts of the case is that contractor was awarded two successful contract buildings, and the contractor one building was a delay by some errors and also determined by the employer for failing to proceed irregularly and diligently. Despite this time, the contractor was reappointed for contractor 2, similar delay, and contractor 2 was also terminated. The contractor sued for wrongful termination and unpaid work over 7 million ringgit, while the government counterclaimed for termination clause. So, the key issue is that the firstly is termination validity. Did the contractor fail to proceed regularly and diligently justify the termination under clause 51 of PWD 203A? Now, the High Court decision that the High Court dismissed the contract claims upheld the termination as valid. Why? The first bit is that meaningly of regularly and diligently. The court interpreted the phrase of regularly and diligently. It held that it requires a contractor to be industrious and hardworking in pursuing the work to meet the completion date. Evidence shows that the contractor lagging behind the schedule, for example, our 49% progress against 100% expectation, and failing to manage the subcontractors and constitute a breach following termination. This case clarifies that the high standards of the performance required to avoid termination under PWD 203A. It also highlights the principle of estoppel contractor that cannot accept the benefits of a new contract, simultaneously challenging and termination of a prior and related contract. So that's all from me, I want to say thank you so much for your time, and I wish see you guys later. Bye bye.